Welcome, everybody. This is one of those bonus live sessions. You don't get attendance points for attending. Generally, the biggest benefit in terms of just the sheer practicality of it is just knowing that it's easier to do well on your assignments for the week. For one thing, it's a little easier to focus if you are live. I am going to now stop broadcasting photos. Videos, excuse me. Thanks, folks. Ask questions until you comprehend the material. I'm not trying to just breeze through. Make sure you know at least one application of every difficult question. It's supposed to be applied learning rather than just, learning something that you're not ever going to use. You want to learn things and figure out a useful bit of knowledge that would come up in paralegal work. Ask questions. My supervising dean is lori.larson@rasmussen.edu. Remember, when you get opportunities to share sources, do so. We're doing summons this time. And if you get a format for a summons, yes, it is good to let me know where you got it. The odd-numbered weeks have a graded live lecture quiz, not Module 4. But I do like to hold one every week, not just for 3 modules. It's the fun part of teaching, for one thing. Jacqueline, do you mind if I mute you? But then unmute yourself when you're ready to talk, okay? Thanks. Just click the microphone when you're ready to talk, okay? The biggest problem with the discussion is really simple. It's easy to pick apart the bad interview, but it's not that super easy to figure out how to interview. In order to figure out how to interview, you want to use your readings and your podcasts, your checklist, and so on. To max out your 10 points for your discussion, use a source and do the start a post with a reply or more than one reply. A lot of students are doing this, but some are holdouts, maybe expecting that they will get full points without doing it correctly, without doing it as a discussion. What are 2 things you want to do in a high-level discussion? You want to give some source for what you're saying so that the person can independently look it up on their own and see if they agree with your take on it, your thoughts on it or not. The other thing you want to do is you don't want to just comment and then quit. You want to show that you are interested in somebody else's point of view as well as your own. So that's a discussion. You're not just broadcasting a one-way broadcast when you're doing a discussion. course project summons and complaint. You don't have Mrs. Johnson's full names. You can invent them, or you can just include the family of deceased as plaintiffs. You're building on what you worked on with knowing criminal from civil in the past. You are using the scenario that you already learned last week, although some students did not learn it. They're not using the lesson content, and then when they come to the assignments, then they're baffled. They don't know what the assignments relate to because they're not reading the lesson content. Well, don't be like that. Be the person that reads the lesson content, knows what the course project is, knows the story about the Johnson family. You know the story about the Johnson family, weeks 4 and 5 are going to make a lot more sense to you. The quiz is on the readings. Generally, they're always on the readings for this week and the week before, so it's on the readings for weeks modules 3 and 4. We will do a little bit of review on that. What should be done to make an interview the best possible interview? Think about skills. What was done wrong and right? What are the magic words journalists use to ask questions that actually get new information? One of the biggest problems that the interviewer had was to just ask for confirmation of, yes, I agree, and things like that, or just getting them to give a yes or no answer, mostly yes answers. Pretty useless. An interview should be asking using who, what, when, where, how, and sometimes why. If you start a question with those words, you will generally almost always be asking an open-ended question for new information, and that's what a real paralegal interview is. Paralegal interview is not a cross-examination where you try to get somebody to confirm or deny facts you already have. Questions, comments on open-ended questions? Open-ended questions lets them say what they want. I do have a lot of problems with students in this and other classes who never, ever ask an open-ended question. It's a bad habit that most of us pick up in everyday life. We will ask a closed-ended question even when we want an open-ended answer, in hopes that person will be polite and wonderful enough to just tell us what we want to know, even if we ask it wrongly. Do you see where I'm coming from? Okay. And I've said this before in other classes, but I use an example of my mother-in-law, bless her memory, wonderful lady. She's very smart, but she could not bring herself to ask open-ended questions. I think partly maybe due to age or whatever, she just had an idea in her head and she just wanted that confirmed. So I'd come back in the car, go to the house, and she was over for supper a lot. So, and she would say, "Did you enjoy playing 18 holes of golf?" And I'd say, "No." "Did you play 9 holes of golf?" "No." And she would just be baffled because every one of her questions, the true, correct, literal answer to every one of her questions was always no, because she always supplied all the information, and the information was always wrong. Now, I had actually hit balls with a golf club on what's called the driving range, which is a practice method. It has nothing to do with playing 9. From my point of view, it does not the same as playing 9 holes of golf or 18 holes of golf. It's like the difference between shooting baskets in the backyard for basketball practice versus actually playing full court basketball. But she couldn't ask, what did you do? Or where did you go in the car? Or where have you been? What did you do? And she couldn't ask, what do you think about that? She was afraid I might say a whole paragraph. She would say, do you agree with this or that? And try to get me to say yes. Now do you get it? Know anybody like that? It's surprising how many students are unable to ask a yes/no question. You really get in the habit of asking yes/no questions when you have teenagers. Have any of you, do any of you have teenagers, or have any of you raised teenagers? Is there any reason why you needed is there any reason why you needed to be up after midnight just to run a simple errand for me? Don't you remember that I said that that midnight is plenty late enough? I realize you have a driver's license, but that is plenty late enough when it's a school night or even on a weekend, so on and so on. Ask yes/no questions, and then, of course, you're not going to get much of a response. It doesn't really open a dialogue. But if you don't want a dialogue, you just want to tell somebody what you think and sort of push them into agreeing with you or whatever. It's not wonderful diplomacy, but sometimes parents do that, put it that way. Is that the attitude you're going to take? Well, open-ended questions basically, who else was there, allows them to say John, Daryl, Jean, Mary. If you say, Jean was there, wasn't she? Maybe the answer would be only no. What are you going to have to ask, like 30 questions to find out who was there? Okay. Okay. Sorry for those of you listening by recording, as I'm getting some good stuff in the chat, but it's personalized stuff. Basically, they're responding to the idea of open-ended questions that sometimes they don't work. And sometimes you have a child or a witness bursting with information, and sometimes you can get them to talk by directing them a little bit, but only a little bit. You might say, I'm not asking this generally. I really am not interested in who you've seen in the last year, but let's bring it to about the time in question. Everybody pretty much agrees that last Thursday is when this thing happened, and that it was somewhere as near this person's, the Johnson's house. Okay? Would you tell me what you saw and heard at that time? We think it was, both sides seem to think it was between 3 and 4. But from your point of view, when was it? What happened? Where were you? How did you get a view of it? Why were you watching? You start asking those kind of questions, then everything works. You can also particularize follow-up questions as long as you ask fully open-ended questions that are not yes or no to start with. You want to look at the partial checklist and the checklist on page 249 of the text to know a little more about how to do a paralegal interview. Like I said, I feel all your pain for those of you that have older kids. It was, I remember when my boys were little, they wanted to tell everything, and then all of a sudden, then they didn't. But of course, I remember when I became a seventh grader, I thought I was too big, because I was large as a person already. I was adult size I was the size of a short adult at seventh grade. So, but I thought I was too big to tell mom and dad everything at that point. And I told them that. I said, I'm not going to tell you everything anymore. So I have my own life. But if it was important, yes, I did tell them. You can ask, please tell me the information I'm missing. Other items I didn't ask, but what you recall. But you have to start out asking them what happened, what did you see, rather than, did you see Bill take the wallet from Dale, look in there, and find his driver's license that he claims to have lost? You don't ask that because you're trying to, that is going to be understood later on when they go to trial. Well, I was coached by the paralegal for this side. They told me to say this thing about the driver's license, but that's not what I actually saw. Now, you want to ask an open-ended question and not tell them what to say. Again, no live lecture points for what we do tonight, but of course you can use this for help to get through Module 4 and do well in the quiz, to do well in the review. If you didn't get federalism correct, certainly work on it, but any questions you have are good. Good question, the question about interviewing. Is this for interviewing someone that our attorney is representing or the opposing party? It could be either one. I have a question in the chat. And interviewing the opposing party or the person representing, because now we may not be allowed to interview the opposing party. More likely, if the opposing party has an attorney, we normally are not going to be allowed to interview that person, but we interview our own side plus witnesses. We are allowed to interview anyone's witnesses. But it is very important that they not get the impression that we're telling them what to do or what to say, excuse me. You don't want a witness on the witness stand who looks at the judge and says, "Can I tell you something, Judge?" The judge says, "Yes, of course you can. What's your problem?" Well, those people over there, pointing at your counsel table where the lawyer you work for is, they told me what to say, and they just tried to get me to agree with it by saying yes or no. Remember that this is civil. A lot of students did pick up on the difference between civil and criminal. A couple of them missed it last time. I think maybe because they're thinking of law as mostly a criminal matter. Never really thought too much about civil. Criminal and family law is better known amongst my students than regular civil lawsuits for money judgments. I'm going to interrupt for another question. If we interview them, it's just an interview, or is it a deposition? Generally, a paralegal would be doing an interview. A paralegal, though, could help prepare for a deposition, but typically the lawyer would be conducting the deposition and actually asking the questions. But the list of questions and the list of categories of questions, the paralegal would help prepare If the lawyer is smart, the lawyer would go through the suggested questions and so on with the paralegal. And it does help if the paralegal has also been working on the documents, such as the complaint. The summons is a standard form. Not really very worried about the summons. If you don't find one for your state quickly, in the state's rules of civil procedure or statute, then just use one that's supplied. I believe there's one that's already supplied for you. Let me look here. Yes. Let's see. Yeah, there is a supplied one. The complaint is really not supplied. The format will help, but we don't want any of the facts that are in the format in the example. Any questions about that? Where to find the facts? Let's see here. Make sure I don't have the wrong stuff up. Okay, summons. Yeah, Microsoft Word. See, here's a summons, but notice that the names are wrong. We're not using these names. We're using so it's the Johnsons against Johnson, okay? In some states, it would be the next of kin or the survivors of. Survivors are next of kin, or estate of Mary E. Johnson versus Dale H. Johnson, okay? And it's civil, okay? Meaning that why is the person being summoned? Not for punishment, but to get a money judgment against them, okay? Okay. Now this you maybe can't see. Have to share it separate maybe. Let's look at, oh, okay, I'll put the complaint up there, but I put the assignment up there first though. I don't understand the question. Natalie asked a question. I don't really understand it. On the bottom of of this that I'm showing the slide, do I want that in there? Oh, no, you don't. No, I typed it just as a teaching tool. You don't even have to use that type of summons. You can use a different summons from a different state. In some states, we don't even type the summons. You do an application. In Minnesota, the lawyer's office does type the summons. In, I believe, Pennsylvania and some other states, the lawyer's office types an application for summons, and the clerk of court issues the summons. Oddly enough, in Minnesota, for some specialized cases, we don't do a summons either. We do just the complaint. Typically, I believe eviction, you still have that, and the court administrator deputy types the summons. But in a normal civil case for money, in a number of different states, the lawyer's office types the summons. The lawyer's office that's doing the lawsuit. Okay, we are going to look at, let's see, the complaint. Notice that this is, again, wrong names, you got to put in different names, and then all of the facts are wrong. All facts are wrong. What are we suing for? We're suing for wrongful death, which is a civil matter to try to collect money from the other side. So we're going to take a look. Where did I get the facts? Where do you get the facts? No, you don't. Where do you get the facts? You're going to go to the Module 3 lesson content, and you're going to scroll down until you get to John and Mary, okay? Then I still gave the wrong name. It's John and Mary. No last name, and I just put Johnson in there, but so this should be John. Sorry about that. Anyway, this is it. The state is going to prosecute it as a murder. We're not doing that today. What we're doing is Mary's family wants to bring a civil lawsuit for wrongful death. So that's trying to collect money. You need to very clearly distinguish between a public prosecution and private lawsuit. The more thoroughly you make this distinction, the more you will understand the cases and proceedings. And there will be more facts as you progress. So we worked on this last week, and now we're working on this part. I also want you to prepare after you do what you need to do. You do your first draft here. I'd like you to start thinking about stage 3. Okay? Why? Why do I want you to work on this early? Because this is going to involve Lexis research to do it really well and get you introduced to paralegal studies version of Lexis. Okay? So early in the week, I want you to do a first draft on the civil complaint and summons. And then later in the week, I want you to work on this. I already prepared a task for you. I gave everybody a tutoring recommendation that you'll all get. And the tutoring recommendation is really to try to get prepared to do this and get tutoring by December 11th. Then you're going to say, well, this week doesn't end. This week ends on the 6th. Why did you give me a task to do for the 11th? It's because this is the hard part of the course right here, is Module 5. So I wanted to give you extra time to set up a tutoring appointment for Module 5. Most students who are starting out are not confident with Lexis, and I want you to be. The other thing I did was I also recommended in the home course, that at some time in the next week and a half, you get a research appointment with our law librarian, okay, which is Dennis Johnson. And this will prompt you on that because that's important. Oh, you couldn't see that? Criminy. Let me try again. Now can you see it? Okay, could you see what I showed you in Module 3, the lesson content? Can you see that? Okay, because that's important. It's important to know about civil federalism and all of this. Civil cases, criminal cases, these are so important. A bunch of students already get this. Some students who have had paralegal experience don't get it because either they've never handled civil or they've never handled criminal stuff. And so they may not really thoroughly get it, even though they've had experience in the law offices. Anyway, you definitely want to be able to, you want to see how this project works, and it's all based on this fact scenario with a few facts added here and there. Basically, it doesn't give the facts of how Mary was killed, though, which is kind of troublesome. Oh, they did it. Yeah, they added the name Johnson, but otherwise, they didn't give all of the facts. I suggested firearms, but you don't have to use that. Anyway, use the summons and complaint. So family of Mary Johnson would be okay, or you can invent more. Like I say, some states you sue on behalf of the estate. Others you just say family, and others you are using next of kin according to the civil law, or survivors. It's a survivorship action. And depending on that state's laws, it may be different people. You know, in some states, you are actually, even if they have children, you are also trying to collect for brothers and sisters of the deceased. So there are differences. Remember, this is a wrongful death case and not a personal injury case, not based on a car accident. Use the course project rubric for these. Summons and caption, well done, and so on. You select the civil court for the student's home state and complete the complaint so it properly sues for a wrongful death in civil court. There should be nothing in there about jail, punishment, prison. It should be an attempt to get a money judgment. The quiz is 30 true-false questions, 60 minutes. Study chapters 9, 11, and the lessons to pass this. Here's a few sample questions. Common law versus enacted. What are they? Which two are enacted, do you think? Of these, A, B, C, and D. Which two? You can just guess one at a time if you want. Enacted means passed by a legislative body of some type. Statutes are passed by a legislature, city ordinances by either the vote of the people or by the city council. So A and D are the correct. So enacted means into law, means this thing. Passed by a body authorized to originate new systematic laws. So judges can make law on special cases, but what they can't do is do a comprehensive ordinance or statute. Most of the time when courts nowadays, because there are so many laws that have been created by legislative bodies and so on, mostly what courts do is interpret rather than make brand new law. Which two are primary? In other words, they are the law rather than a comment on the law. I should have done these A, B, C, and D, shouldn't I? Oh, that's A, B. That's kind of impossible. C, D. Well, case law is primary. Statutes are primary. Yep, you are correct. Which two are secondary and not enforceable? Lawyers' blogs and ABA model rules of professional conduct. This is enforceable. The judge has to follow it, and the court administrator, and of course the parties. This is enforceable. And the Constitution, of course, is enforceable. And lawyers' blogs, of course, are not enforceable. and ABA model roles are just models. Reporter is not a reporter. In other words, they're not like a newspaper reporter. They're case law bound volumes called reporters. And yes, there are electronic versions of them as what we customarily read nowadays. And I'm not going to go more on your learning methods and such. I'm just going to pause and see if there's additional questions that I did not answer correctly. It would help if, in answer to Natalie, yes, it would help if I knew where you got your form. But you don't need to get new samples necessarily because you already have them in the assignment. What state are you in? Well, then you definitely don't need new samples. Students from other states might want to look at their home state's summons if they can find it, or get help from me to get one. What is a complaint, by the way? And this is very multi-state. Every state I've looked at wants the same things for a complaint. And I'll put it on the board here. I don't want you to do a canned one. Okay. Does that make sense? Don't do a canned one. In other words, an example. Don't use example language of a complaint. I don't want to see something that looks like it was made by a lawyer, okay? I want a plain statement. In a numbered paragraph. I would say numbered sentences even. They say paragraphs, but I want it in numbered sentences. And I will explain that more if I teach you in civil litigation, but I want numbered sentences. So there's reasons for doing it that way. It makes the complaint much clearer and much easier for the judge to evaluate it. The other side to answer each of the sentences accurately. If you make it into a bunch of multi-sentence paragraphs, it muddies the waters because they end up admitting part of it, denying part of it on each numbered unit, each numbered paragraph. So I want a bunch of one-sentence paragraphs, each with a number in front of them. So tell what happened in numbered sentences. At the end, ask for money. And you don't have to ask for a specific amount, but you can. This would be good enough. And I'm not going to make you use the word disbursements and so on. The fancier it is, the worse. The more that I'm going to think that you just pulled it out of some form. And frankly, lawyers do this wrong. It's supposed to be a plain statement of facts according to state laws and state rules. That's actually what it says. If you get past the legal jargon, the more legal jargon you put in there, the more you messed it up. If the lawyer wants legal jargon, the lawyer can always add that in if they want it for some reason. But the law actually says that it should be a plain statement of the facts that support the lawsuit. Okay. What students have gotten wrong in the past is they put too much into each paragraph. They haven't numbered the paragraphs. They have gotten far afield on the facts. They started, they reuse somebody else's facts that they found. You may add your own facts. You may add fictional facts to it, but don't add somebody else's from some other form, okay? Don't use auto accident facts or any facts you find outside the assignment. But you may add facts to the John and Mary Johnson case that's in Module 3, okay? Okay. Any questions about that, problems? I'm going to stop and give you the rest of the time to work on it, okay? If you find a wonderful summons form in your home state, and you can certainly use it, but you can certainly check it out with me because, like I said, it gets kind of complicated. Your state may not even have something that the law office does that looks like this. Your state may have an application for summons, and then the actual summons is made out by the clerk of court. So don't be afraid to contact me if you have difficulties of any kind.